We'll call this September 18, 2019 meeting of the Planning, Zoning, Agriculture Committee to order. Roll call, please.
Mr. Olthoff? Mr. Featherling?
Present.
Mr. Washington?
Present.
Mr. Tholen? Ms. Polk?
Present.
Mr. Payton? Ms. Peters? Ms. Dunbar? Mr. Kinzinger?
Present.
Mr. Fairfield?
Present.
Mr. Smith? Mr. Swanson?
Present.
Mr. Dunnell?
Present.
Mr. Wheeler? Mr. Seroy?
Present.
We have a quorum.
Thank you. We have public comment this morning. Kim Snyder would be the first one. Would you take the microphone there in the back? Thank you. Certainly.
Might be out of the range of the video, so move to the front. Like, go to the front mic, go to the front mic. Because we're in the big video cameras right there. Thanks. Yeah, my name, am I on?
Yes, you're on.
Okay. Yeah, my name's Larry Serene. I'm an attorney in Kankakee, and I'm representing Kim Schneider, who's seated in the back. And there's another gentleman by the name of Dave Franson, who is also going to get up and speak for a minute or so. Kim is, she owns 32.27 acres. I think it's in Salina Township. And she, in 2004, she built a residence on this property, and she and her daughter now live in that residence because of, well, she raises some specialty animals, specialty crops. She has certain special customers. She goes to Chicago and makes her living by selling these products. She's come into some financial difficulty. And because of the financial difficulty, she worked out a plan to sell off 28 acres to an adjoining landowner who was willing to buy the 28 acres and lease the 28 acres back to Kim so that she could continue with the operation as if nothing happened, so to speak. Originally, she was advised that she could get the farmstead exemption, and so she proceeded with all her due diligence, entered into a contract, got the survey, made the application or talked to about the farmstead exemption, and learned that she couldn't do it because the house was built in '04. So she is petitioning to have 4.27 acres rezoned as rural estate, and then she would proceed as originally planned by selling the 28 acres, raising the money, leasing it back, and proceeding with the farming operation. So the once this is completed, to any other observer, it would almost be as if nothing had changed. It's still going to be used as agricultural purposes, just as she has been for the years. I think the point of it is she proceeded with what she thought she could do. This is not something that she's doing willy-nilly. She's doing this, she's asking for this rezoning because she has to. She has no alternative. So we ask respectfully that it be rezoned. Thank you.
Okay. Thank you. Larry Serene. Oh, so you spoke for Kim Snyder. All right, David Franson.
Good morning. My name is Dave Franson. I'm representing my cousin, Therese Tucker, who is the buyer, and she lives in California. She owns a lot of the property in the area around Kim's farm, and I oversee these properties for her. Kim's farm was part of my cousin's great-grandparents' farm, and one of her motivations in buying this is, and much of the land on the 1000 road that she owns, is she's trying to put back together the farm that her great-grandparents and grandparents and parents held. And she's done a lot of that over the last number of years. And that's really her motivation here. As Kim is an organic type farmer, she's also very interested in that out of honor and respect of her dad, who was an organic farmer. And her motivation is really just to put the farm back together. She's not looking to develop this property. She's not looking to make any changes. If Kim does not farm the property or leaves, it's going to remain a farm. And that's really her motivation: put the family farm back together and keep it all within the family. So,
Okay.
any questions I can answer?
No. Thank you.
Thank you.
Mhm. John Beavis, please.
Good morning. My name is John Beavis. I'm the administrator for the Kankakee County Health Department. I just wanted to talk for a few moments on the topic that I saw on the agenda for today, and I know that it's being talked about all over the state in regards to the Illinois legalizing the recreational sale of marijuana that will start in 2020. So communities all across the state, including here, are having to decide whether they're going to opt in or opt out. If they're going to allow it, what are going to be the rules and regulations? So I just wanted to talk a little bit about marijuana's impact on public health from the standpoint of my experiences working in public health for all these years. Marijuana is addictive, according to the National Institute on Drug Abuse. 9% of adult users become affected. Teenagers have nearly double the chance of becoming addicted because they're still developing, and more than 17% if they start as adolescents. And by passing the law in Illinois, statistically it'll probably be shown, compared to a lot of these other states that have done it also, is that they're already seeing increases in, because the public and the youth will say, well, it's allowed, kind of like drinking, so it must be safe, so I'm going to do it. And then they become addicted, and then there's all these health effects that come after that. Marijuana and the opioid crisis. There are 2 studies that have been done recently that show that marijuana may not be the solution to the opioid crisis as being preached by the industry. The opioid crisis appears to be worsening, actually, where marijuana has been legalized despite fewer opioid prescriptions. So as we get the prescriptions decreasing, now that we have a lot more knowledge out there in regards to how people are becoming addicted, why they're becoming addicted, we're still seeing opioid overdoses on the rise because of that. Marijuana's impact on mental health is, there is substantial evidence to show that it helps to develop schizophrenia, the increased risk for the development of depressive disorders, increased incident of suicide ideation and suicide attempts, increased suicide completion, and increased incident of societal anxiety with regular cannabis use. And I know it's impacted my family in regards to anxiety issues, and I've talked to a number of people with today and what's going on in the world. There's just a lot of anxiety out there, and this is just another avenue that could help increase that impact. There is an impact on maternal and child health. So at the health department and at other health agencies and hospitals, we will begin to see some of the ramifications of this. The American College of Obstetricians and Gynecologists recommends against the use of cannabis in pregnant women. However, there are studies that show that they are using it, and there was even a study of 400 Colorado dispensaries that indicated that 69% of those 400 surveyed were recommending treatment of morning sickness to these individuals of smoking the marijuana. The track record in Colorado, there are studies now that show, after all the years that they have passed this, that the marijuana-related hospitalizations have increased by 236% since 2014. The marijuana-related emergency room visits increased by 24%. And I just want to make sure you understand that when we're talking about the marijuana today compared to the marijuana of, when I was a youth, the 70s, the 80s, and maybe even the early 90s, the potency of this marijuana is 10 to almost 90 times stronger. Okay, so what basically the dispensaries are able to create and make marijuana on steroids now, and then that's what they're going to be selling to individuals. 69% of marijuana users admit to driving after using marijuana. So not only do I have to contend with alcoholism and drinkers and drunk drivers on the road, I'm going to have to contend about either people who are high or high and drunk too. Auto crashes in Colorado are up 13% since legalization. Marijuana-related traffic deaths increased 151%. They had 55 and 213. There were 138 in 2017. For every dollar of tax revenue that Colorado gained, they spent $450 on the backside in public health. So the investors are going to get rich, the dispensaries are going to get rich. That's going to be on the backs of you and me and my family that would be impacted by this later down the road in regards to the health issues in our community. The last thing I would want to say is also that's not really being talked about is there are a lot of communities with the workforce and the industries that are concerned about what is this going to mean for people who have to pass a drug test. There's enough trouble right now for individuals to be hired into the trucking industry, the driving, anybody who drives for a living, doctors, people who work in the health industry. Do you want somebody who's been smoking the night before to be treating you if they're going to be doing surgery on your brain or any kind of surgery or procedure, or driving a semi that you're going to be on the road for? So those are the kind of impacts that we're concerned about and that the state is concerned about in relation to this. So I understand that the law is passed, it's legalized. That doesn't mean that the community has to allow it or allow it to be sold in its area. So I would promote that we not do that. Thank you.
Thank you. You received a copy of the August 21, 2019 minutes. Any additions or corrections? Motion to approve would be in order. Mr. Dunhill and Mr. Washington. All in favor say aye. Aye. Opposed? Motion carried. Going on to Stormwater MS4 program discussion.
Every month I'm required by our Stormwater MS4 program to ask if any of the board members have any issues with stormwater that they'd like to discuss.
Then going on to Stormwater ordinance update.
Okay. A few months back, I believe it was around June, Mr. Mike Gingrich gave a presentation to this committee to update our stormwater ordinance in regards to how impervious surface is calculated on existing developments when additions are being made to existing developments. At that time, the committee voted to recommend the ordinance update, but we held it off to make sure that we had ample time for the other engineers in the county to take a look at it and make sure they were on board. So I'm here to report that that has been done, and all the other engineers have no issues with the change. So we're asking today for you to re-recommend the changes to that ordinance. I believe Mr. Gingrich does have copies of it. Did you bring copies? If somebody needs to see it.
Is there a motion? Mr. Washington? Mr. Featherling? Any discussion now? Mike, could you give me one? It's not in the packet, right?
No, it was not.
Okay, thank you. You want one for Andy? Okay. Mr. Kinzinger.
In common language,
Mike?
in common language, what was the necessity for the revision?
I'll let Mr. Gingrich explain that.
The stormwater management ordinance, when it was adopted, did not address the redevelopment of property or the additions to an existing property. So in the case of a facility like CSL or Nucor, or even more so some of the smaller facilities, when they did a building addition that required a Class 2 grading and drainage permit, they basically were required to bring the entire facility up to the release rates in the ordinance, which basically meant they couldn't do anything. In fact, they would probably have to take down part of their facility to make enough room to make that space available for stormwater. So we recommended an adjustment. It's right there on the first page, where we would allow a higher release rate based on existing impervious area. So
That's the significance of the 2006 date.
yes.
Thank you.
Any others? You have a motion before you. All in favor, say aye.
Aye.
Opposed, same. Motion carried. Thank you. Going on to ZBA case under zoning 1910. Request for rezoning from A1 Agriculture District to Rural Estate District on a parcel generally situated in section 25 of Salina Township. The petition is State Bank of Herscher, trust number 1241, property owner Kimberly J. Schneider, applicant.
Kelly, could you switch over?
I believe Kim Schneider registered to speak.
I called her name and you came up. Okay,
I'm sorry,
all right. Kim, you want to speak? All right, would you take the mic over there? Hmm? Yeah.
So I bought this
I know.
piece of land in 2004, and I raise old heritage cattle and hogs on rotational pasture, and I raised my daughter there. And sorry, it's very emotional for me, but I have had financial issues. I feel very blessed that the adjoining landowner happened to buy her family land that she wants back, but she wants it to be farmed exactly the way I farm. So she's able to purchase it and allow me to continue raising my daughter there and earning my living. Unfortunately, I built 1 year after it was voted rural estate, and so that's why I'm here asking permission to split off part of my land. It will be transparent to the community, hopefully transparent to my client base, and I'll continue to do what I've been doing the last 15 years and continue to raise my daughter in the Herscher School District.
Okay. Thank you. All right, Del.
Okay, this is a request for rezoning from A1 Agriculture to RE Rural Estate on the property shown on the monitor up there. The 32 acres is the overall parcel. The area being divided is 4.27 acres and outlined in red. It contains a single-family home and some smaller agricultural outbuildings. As stated in the public comment portion of the meeting, at the public hearing, the applicant testified that they are having financial difficulties, can no longer afford to keep the entire property, and would like to sell the remaining portion to an adjoining farmer so that it could be farmed, and that they intend to lease it back from that farmer. Zoning Board of Appeals heard this request Monday night on the 16th and recommended approval 6-1. There was no objection.
If it was 5 acres, that wouldn't make any difference because it was 2004 is when the...
No, that is not correct. Originally, Ms. Snyder's previous attorney had filed an application for a farmstead exemption, which allows you to cut between 1 and 5 acres off of the farm with the home. The problem with that is that the home had to be in existence prior to 2002. This home was built in 2004.
Okay.
So we had to deny the farmstead exemption, and rezoning is the only other option.
All right. Any questions? What, do we need a motion first? Motion to approve, and seconded by Mr. Seroyes. Ms. Dunbar made the motion. All right, now, Mr. Kinzinger.
Just so I can wrap my head around this. Just so I can wrap my head around this. The issue is, had this house been built 2 years earlier, it would have qualified under some provision that we have in the county now.
That is correct.
Thank you.
Any others? Mr. Featherling.
Was any explanation gave for the no vote? Did they give descriptions of which finding it did they didn't feel as though it?
No, they did not.
They did not. Okay, thank you.
Any others? All in favor, say aye.
Aye.
Opposed? Motion carried. Okay, going on to ZBA case 1911, request for text amendment to County Code Section 121-293, home occupations. Petitioner is Kankakee County.
Planning staff has been looking at updating our home occupation portion of the zoning ordinance for a while now. And over the summer, we presented it to the Regional Planning Commission and worked out all the details with them, and they recommended that we bring it forward. At last month's meeting of the Planning and Zoning Committee, this committee also recommended that we go to public hearing with it. We held that public hearing Monday night. If you recall, last month I gave a few examples of why we were doing this. This is typically what you think of when you think of a home occupation, and would certainly be allowed by our current ordinance. But then we have something like this, which in actuality could also be allowed by our current ordinance. So we wanted to tighten up those regulations to prevent this. Home occupations are meant to be a small business venture operated in the home to make some additional income, not a full business venture. If you want a full business venture, you should move your business to the commercial district where it belongs. So our current ordinance only has 4 provisions in it. It's pretty light. Simply says you can have a 2 square foot sign, that no deliveries larger than a mail delivery vehicle or passenger vehicle. You're only allowed to have 1 additional member that doesn't reside in the home working at the business. And you can't use any accessory buildings in whole or in part. That's very weak for a home occupation ordinance. It allows a lot of things that can become a nuisance to a neighborhood. So we looked at the whole ordinance and we proposed the following. The operator of a home occupation must be a full-time resident of the dwelling unit. They can be a renter, but they must live there. So you can't just take a home and turn it into a business and walk away from it. No more than 1 non-resident can be engaged in the conduct of the home occupation, so we kept that from the old ordinance. We clarified that the use of the dwelling for home occupation must be clearly incidental to the home. The principal and prime use of the home must still be a residential use. And we did limit the floor area devoted to the home occupation to 30% of the entire dwelling unit's floor area. So that gives a bit of a restriction on how large it can be. Must be conducted within the dwelling unit, and no accessory structure shall be used. We kept that from the old ordinance. It must not involve any outdoor storage, displays, or other outdoor activities. The smaller size passenger vehicles and mail delivery trucks from the previous ordinance we kept, that would be item G. And H, there shall be no visible evidence of the conduct of a home occupation when viewed from the street right away or from an adjacent lot, except for the permitted nameplate sign. There should be no changes in the exterior appearance of the dwelling unit that houses the home occupation or site upon which it is conducted that will make the dwelling appear less residential in nature or function. We added that. We added in some performance standards. No equipment or processing shall be used that creates noise, vibration, glare, fumes, odor, health hazards as recommended by Mr. Kinzinger, or electrical interference. And then we, on the advice of Mr. Wheeler, at the last planning and zoning meeting, we did do some changes to the signage. On parcels 1 acre or less in size, you're allowed a 2 square foot nameplate sign attached to the principal structure. On parcels larger than 1 acre, you're allowed a 12 square foot sign, 10 feet from the right of way, no taller than 6 feet in height. That's so that a larger parcel, that the home might be a few hundred feet back from the road. Obviously, you're not going to see a 2 square foot sign attached to that building, so this would allow them, their customers, a way to locate them. And under no circumstances shall any of these signs be illuminated, flashing, an electronic display, or have moving parts. This went to the zoning board Monday night on the 16th, and they voted 7-0 to recommend the approval of the changes.
Okay, is there a motion to approve? Ms. Dunbar, seconded by Mr. Washington. Discussion. I've got a question. If a dairy farmer was wanting to sell raw milk, would he qualify?
No, that would be an agricultural operation and would be exempt from our zoning ordinance.
Okay.
That is not a home occupation.
All right, he could do that. All right, not like a farm stand, right? Mr. Kinzinger.
Whenever I go to a zoning meeting, one of the first questions they ask me is parking. I'm thinking of a bingo parlor one night a week, a number of phone calls with cars parking it. How do we handle car parking? I don't know what kind of business we're
Bingo
talking about.
parlor would not be a home occupation in my eyes anyway. But there's an entire section of our ordinance for parking, and depending on the use in the zoning district, it tells you the number of
So the
cars
way
you
this
would
is
need.
written, could we apply that parking ordinance to this particular issue if we had a problem?
Absolutely.
Okay, very good, thank you.
It's all part of the same ordinance. This is just a small section of the zoning ordinance being changed.
Thank you.
It actually fits into the overall zoning ordinance.
Okay, any other questions? Number 5, Mr. Smith.
Thank you, sir. Dell, I've got 2 questions. One, the first one deals with the home occupations in a separated structure. Is this ordinance being generated to go after those existing businesses in the county now that operate as a home occupation?
Well, if they're operating now, they should not be in a separate structure. They would already be in violation of our ordinance, because our current ordinance only allows it in the home as well.
And then,
So they would be in violation. If a home occupation is currently legally and lawfully established, they would be a legal nonconforming use if they do not meet the current ordinance and would be allowed to continue. If they're not lawfully established and legally operating, then
how do I
they
find out
wouldn't
if
be
they are?
now. What's that?
How do I find out if they are currently established?
We do not have a list of them. We give people the ordinance and say this is what you have to meet. And if they're following the ordinance, we shouldn't know they're there except for the sign. So we do not have a list of where they're all at. We usually find out about the ones that are not meeting the ordinance when we get complaints.
And mail delivery, that's UPS, FedEx, all these others.
That type of a truck, yes. Basically what that means is no regular semi-truck deliveries.
That's it. Mr. Siroy.
Thank you, Mr. Chairman. Dell, do you know of any home, I guess this kind of piggybacks on what Mr. Smith said. Do you know of any home occupation that these new regulations would affect?
I didn't know.
Okay.
I do not.
So there's none that might be affected by the new regulations that you know of?
No, there would have been one, but they have closed down.
Okay. That was my thing. If
that
they,
one was the one that actually prompted us to look into this.
All right. I was wondering if we had one, would you allow a grace period to, or a time frame to get their stuff in order to comply with the new?
Well, in fact, that one would have been because it was established under the old ordinance, would have still been legal non-conforming, so it would have been allowed to stay.
Okay.
In that instance, I believe it was they added a 4 or 5 car garage to the home and turned it into a retail space. That's what we're trying to prevent. Okay.
Thank you.
If there's a business going on in a separate building, no signage, just people who know it's there, and it's been there for 15 years, is that legal non-conforming?
Not necessarily. It would have to be looked at. 15 years does not make it legal non-conforming. It would have to actually predate our ordinance in 1967 to be legal non-conforming for sure. Anything that existed prior to us having an ordinance is definitely legal non-conforming.
Okay.
After that, we would have to look at what it is, where it is. There are other ways to have businesses in your home as well. There's a rural-based service provider in the A1 agricultural district that does allow you to use accessory structures. You can apply for that. We do not have that many of them that have been approved throughout the county, but they are there. So that's another option. If you, that seems to be popular with the building contractors, plumbers, landscapers, because then they can use their accessory structures to house their equipment and such. We did just issue one out by Union Hill for a plumbing business. They wanted to build a pole barn out behind their house to house their equipment, and that was approved. That's an entirely different section of the ordinance, though.
Okay.
Home occupations are simply that, meant to be in the home.
All right.
So if you don't want it in the home and you want it elsewhere, there are other options.
Okay. Mr. Smith?
Not particular to this, but your exception to that, is there a minimum land requirement for that?
For what?
Acreage?
For which ones?
For the outside building?
No, the rural-based service provider does not have a lot minimum, other
Okay.
than the A1 district, which has a lot size minimum of 5 acres.
So if I want to turn my tool shed into something, technically I could.
You have to apply for it. What you for the rural-based service provider, you send letters out to all of your neighbors telling them what you're doing. If they don't object to it, we issue it. If you do get an objection, then it becomes a zoning case, goes before the zoning board of appeals, and ultimately the county board for approval.
Right.
We have not had one do that yet. So.
Okay. Ready for vote? All in favor, say aye.
Aye.
Opposed? Motion carried. Going on to ZBA case 9-12, request for a text amendment to County Code Section 121-3, 121-182, 121-183, 121-208, and 121-209, cannabis dispensing facility. The petitioner is Kankakee County.
Yes, this is another text amendment. 2013, Illinois passed the Compassionate Use of Medical Cannabis Pilot Program Act. It's been on the books for a while. At that time, we amended our ordinance to allow both dispensaries and growing facilities according to that state statute. And I have them on the screen. There's a definition for both cultivation centers and dispensing organizations. It's a lot to read, but it fits that state statute at the time. This is currently what we have in our ordinance. And then we allowed both types of facilities to be special use permits in our I1, I2 light industrial districts. Then we have a proposed ordinance to allow for the new Cannabis Act that will go into effect January 1st, 2020. Everything, it's in your packet. Everything in yellow is being added. Everything with a strike through is being removed. We've removed any reference to medical, since it doesn't really matter anymore whether it's not strictly medical. We have added we have not made any changes to the growing facility part of the ordinance, but the dispensing facility part, we've added the dispensing facilities of special use permits in both the C1 and C2 districts, as well as keeping them in the I1 and I2 districts. They are special uses, which allows the county board the ability to put conditions upon them and gives the county board control. If it's a permitted use, it can simply be done as long as you meet the ordinance. With a special use permit, you must ask the county board's permission, even if you meet all items of the ordinance. So the county board does have control as to where they are and what gets approved and what does not. So here's the bulk of the ordinance. The cannabis dispensing facility shall be set back a minimum of 1,000 feet. Originally, I had wrote in 2,500 feet based on guidance from this committee. The zoning board felt that 2,500 feet, which is almost a half a mile, was too much, and felt that 1,000 feet was more appropriate. From schools, playgrounds, parks, religious facilities, we added in the word adult community residential home. We added adult to that instead of just community residential homes. Penal institutions, manufactured home communities or parks, and registered daycare facilities existing at the time of their establishment. And what that last line means is that you can't have a dispensing facility established and then try to get it kicked out because you established a daycare center within that 1,000 feet later. So that's at the time of its establishment. Cannabis dispensing facilities shall be set back a distance of 1,000 feet from property zoned R1 single family residential, R2 high density residential, and RE rural estate, and properties within platted residential subdivisions regardless of their zoning district classification. We do have a fair amount of subdivisions in the county that are still zoned A1 agriculture and has never been changed. So that's why we put that line in there. Cannabis dispensing facilities shall only be established in a freestanding structure, not occupied by any other business tenant or used for any purpose other than a cannabis dispensary, so no sharing. However, they can share a parking lot. So you could have two different uses sharing a parking lot.
Mr. Featherling?
Yeah, it has to be a standalone freestanding structure. It can't go in a strip center or in a shopping center.
Not according to our ordinance. Keep in mind, the county doesn't have any strip centers or shopping centers in unincorporated Kankakee County.
It's unincorporated.
So it'd be municipality, they have their own.
But if we were to have one, no, it would have to be a freestanding structure.
Okay, thanks.
Zoning board chose to remove number 5, where no cannabis or cannabis-related products shall be consumed on the premises of a cannabis dispensing facility. After reviewing the statute, it is allowed by state statute, so that one was removed.
Number 5 was removed?
Yes. So in red is removed from our original application. Okay. Number 6, with the exception of advertising and signage, all business operations of this dispensing facility shall be conducted within the confines of an enclosed structure, and under no circumstance shall the sale of cannabis or cannabis-related products be conducted outdoors. Number 7, cannabis dispensing facilities shall comply with all other provisions of this ordinance and regulating state statutes. And that is the bulk of the ordinance there.
We're gonna have to have a motion first. Is there a motion by Ms. Dunbar to what? Approve, okay. Seconded by Mr. Washington. Now discussion,
By
Mr.
the way,
Kinzinger.
this was recommended by the Zoning Board of Appeals, 5-0.
Mr. Kinzinger.
Yeah, I'm curious as to why we inserted the word manufactured home community rather than just home community. It would appear that we're specializing in a certain type of home rather than a home.
Well, we covered that with the residential districts in number 2.
So are we picking on manufactured homes or manufactured, or what are we picking on when we spell that out?
I don't believe we're picking on anyone.
Why
I
would we put
believe
the
that
word-
was added because of the concentration of children in a.
Well,
those types
don't
of
regular home
facility.
communities have children?
They do, and we spell that out in number 2.
So you're trying to catch both
R1
of
single
them.
family, yes. Basically, anywhere there's a concentration of residences.
Okay,
The
trailer parks aren't an
manufactured
R1.
home community is more of a use, whereas in number 2, we talk about the different zoning districts, the residential zoning districts.
So a manufactured home community is not an R1 or an R2?
No, that's actually a special use in our A1
Understand.
district, so
Thank
that's
you.
why we had to call it out
Thank you.
differently. Okay.
Any others? Mr. Smith?
Just a question, Dell. The ability to opt out totally. Do we still have that, or does this ordinance, by approving it, saying
I don't believe you have an option to opt out totally. You have the option of whether you want to tax these type of facilities and whether you want these facilities in your county. The transportation, use, and possession of marijuana is still legal, will still be legal throughout
I'm talking
State of Illinois.
like the villages are doing up north, one by one, they're opting out of the sale in their jurisdictions.
Right, now what they're saying is we're not going to approve any of these type of facilities, and we're not going to impose the tax
So
because we
by-
don't have these facilities.
I couldn't care less about the tax. I agree with the health department advocate that it's going to be more of a pain than it's going to be a benefit. The ability for the county to say we do not want this, if we pass this ordinance, are we bypassing the ability to opt out for the sale of marijuana in the unincorporated area?
Not in my opinion, no. What this does is puts regulations on the books for anyone who's wanting to do it, for them to follow. It will be up to the county board on a case-by-case basis whether they want to allow it or not. This is just simply zoning and land use, is what this is. So you're providing a location for these if someone wants to do it. Because it's a special use permit and they have to ask permission, the county board can always deny it. And it's possible to deny every one if you'd like.
If we do not have this ordinance, does that preclude the ability of any business to come in and say they want to do it?
It's better to have it on the books for them to ask for and deny than to not have it on the books at all. If it's not in the ordinance, it could be argued that if it's not listed, it's allowed. And it's allowed anywhere because it's not listed in any particular district. And there have been court cases where that has came through. So by putting it in a specific district, setting up regulations for them to follow, you have covered that part of it. Is that clear, or is it?
If we don't pass
You're
this
taking that
ordinance,
argument away.
if we don't pass this ordinance, you're saying it still could happen?
That's what he said.
I believe so. If you don't pass this ordinance giving a location for them to be in, it is quite possible that
Then they'd be violating,
could.
wouldn't they?
there's no ordinance for them to violate. What ordinance would they be violating if it's not in the ordinance?
Just a minute. Mr. Kinzinger was first.
I'll defer to Mr. Sirois because I'm
Okay.
with Mr. Smith.
I'm not sure it's wise, but go ahead.
Thank you, Mr. Chairman. I think what Dell is trying to say is if we don't have an ordinance intact, that we can't issue special use permits and then like solar farms, be able to deny one and accept one. If we don't have an ordinance intact, then anybody can build one anywhere and we have no real jurisdiction on that because it's already state law. Does that make sense? Did I
It
help?
could be construed that way.
is that
has
true?
happened with adult uses before.
Yeah.
That's why
So
we
I
have
think
an adult
that's
use ordinance.
this would cover us. So if Mr. Smith didn't want anybody in his district to have a dispensary, or anyone in my district to have a dispensary, we could lobby the board to disallow that, just like we have on solar farms type.
Okay, am I understanding this correctly, adding on to what you're saying? If we pass this ordinance and we go on to the next thing, allowance for cannabis dispensing facility in unincorporated area, we can vote that down.
Well,
And then they still couldn't do it in the unincorporated area, but we've got an ordinance.
well, we don't. I don't think we have any paper. This is just a discussion for the next portion that's kind of leading into this discussion. Okay, so if we don't have an ordinance to set regulations, but the state does. We really don't have any teeth or control, right? Yes. So we don't have any control. By having an ordinance, we have control to some portions of this, and also they have to have a special use permit that we would vote on as a board. Now, to the second part, I don't think we have any applications for dispensaries.
We do not.
So that was leading into this whole discussion.
What are we discussing with the next item then?
Well, the sales tax portions of it and the revenue from it. And I'll wait to talk about that.
Thank you.
Thank you.
Mr. Kinzinger.
I wish I hadn't deferred.
I
My understanding was that the next item was a vote whether to allow or not allow residential dispensaries within the county, and that this vote regarding this ordinance was in the event that we did end up with recreational sales, we would have an ordinance in effect. Now, if we're voting on this ordinance, which automatically allows residential dispensaries, then I'm opposed. I think we're out of order in terms of the way we should do things. Mayor Lightfoot in the Chicago Tribune just this morning, major front page article trying to ban recreational sales in downtown Chicago, which has more tax problems than this county ever had. What's the other one? Naperville banned recreational sales. Now, whether the order was they have the ordinance and now they're gonna vote against it, that's fine. But if we wanna vote against it, and this ordinance makes it so we can't vote against it, then I'm opposed to this ordinance.
I don't see how this ordinance keeps you from voting against it.
Well, what Mr. Siroy said indicated the only thing we're gonna talk about next is how we collect the taxes.
No, sir. And I apologize, Mr. Kinzinger.
Are you done, Mr. Kinzinger?
Yes.
Okay,
I
Mr.
apologize, Mr. Kinzinger. This ordinance allows us more control. If we have no ordinance, if we vote this down and have no ordinance, they can build one in my backyard and I can't say anything about it because they're gonna go with the state ordinance.
Is that
Yes.
true?
To an extent, yes. The state statute allows the local governments to put zoning regulations and restrictions upon the siting of these facilities.
So if we don't want it in the county, we'd have to say no, there absolutely can't have zoning. I mean, can't,
From a zoning standpoint, it's always been our contention that if it's not in our ordinance, you can't do it. But there have been court cases where it's been overturned. That type of opinion's been overturned, especially in the adult use area, that if it is in your ordinance, it's allowed. And it's allowed anywhere if it's not in your ordinance. So
Okay.
what we're trying to do is put it in a location where it's least harmful, put some restrictions on it, and then the county board on a case-by-case basis later on can decide whether they want to allow
if
them or not.
if we had an ordinance that says there will be no cannabis dispensing units in the unincorporated areas of Kankakee County.
And that is certainly something you could do. It's not a zoning issue.
So we would not forward something like that to the county board.
That'd be an executive committee issue.
That's
I believe.
executive committee.
But that doesn't hurt this ordinance. If this ordinance gets put on the books and then you were to pass an ordinance like that, then this part of the ordinance just couldn't be used.
Just a minute. Ms. Dunbar, number 15?
Correct. Thank you, Mr. Chairman. So Dell, I guess I just want to clarify one more time. If we have an ordinance that makes this a special use, it has to be brought before the board every time somebody requests it.
Exactly.
And so we have the opportunity, because we have this ordinance, to turn down every single one on a case-by-case or approve every single one on a case-by-case basis because it's special use. And that's the beauty of a special use permit, correct?
Correct. Or any combination thereof. You can approve
Right.
some, deny others. You can put conditions on
Right.
it, hours of operation, various other conditions upon it.
And so this
if
gives,
you wanted to approve it.
this gives the board control on every single request that we get.
Exactly, on a
Thank you.
case-by-case basis. So passing this ordinance is not approving
doesn't approve it,
cannabis
it just
sales in
gives us
the
control
county of
over it.
Kankakee. That's correct.
Mr. Fairfield?
Well, if you have this ordinance and just like the solar farms, you'll wind up with somebody applying for it and the board votes against it, that opens us up for lawsuit. Isn't that correct?
Everything we do opens us up for.
I understand that, but I'm just saying, if you have this ordinance and all of a sudden somebody comes in, you say, I don't want it there, and you don't have a good enough reason to vote it down in the county, then that opens the county up for lawsuit because we're denying them access to their business, right?
Certainly possible. Not having the ordinance could open you up to a lawsuit too, because somebody wants to do it and it's not in our ordinance, so we're gonna try to stop them, and they're probably going to sue saying it's not in our ordinance, we can do it anywhere we'd like. And therefore, we're still gonna get sued. So either, that's a possibility either way you go there. How you can prevent that is by having good reasons to deny it, following the proper procedures.
Philosophy is not a good reason.
No, actually not.
Thank you, Mr. Chairman. And I just would like to remind the committee that we didn't create this law. This isn't our law to stop. We can't, our legislator in the state created this law. So it's our law to regulate. But we didn't create this. We can't prevent this to happen in our county. It's gonna happen. We're gonna walk into Walmart and you're gonna smell it. Like you smell cigarettes. I'm just saying, it's gonna happen. We can't prevent it from happening here. It's the state law.
That's an incorporated area, right?
Unincorporated is what we're talking about.
What I mean
but-
is, you might go to church and you smell it. It's gonna be everywhere.
Like I said,
sorry.
the use, the transportation, the possession of it will still be legal in Kankakee County, regardless of what you do on this ordinance.
That's what I'm trying to say.
Mr. Kinzinger?
Sometimes things are more important than money. And what I'm hearing here is a level of confusion, but it looks to me like the safest vote is nay on this ordinance or on this change in order to at least symbolize an ordinance or put together some type of ordinance that says we're not allowing residential dispensaries in Kankakee County. Now, we may be overruled, but something has to start somewhere. That's all I have to say.
Mr. Smith?
I'm just not sure how to go about this. Whether we can make a motion to table this in lieu of getting a resolution or whatever to say we are not going to have dispensaries in the rural area.
Would you refer it to the state's attorney to put a resolution together?
Whatever the proper procedure is, whether it goes to executive or whatever, but I can't vote for this today.
Ms. Dunbar?
Thank you, Mr. Chairman. I think Dell said earlier, and I agree, that there's two separate issues here. There's the sale and consumption and taxing and all of that, and then there's land use. And this is restricting land use. This is simply an ordinance to regulate the use of the land. And I think it's a separate issue to say we're not going to allow them. This gives us the restrictions on the land and the petition, the requests for dispensaries to be able to control that. And we can ask the state's attorney to look at a separate resolution, ordinance, whatever it is. But this is a zoning issue.
Would you be against any dispensing in the unincorporated area of Kankakee County if it came up?
I don't think that's relevant to this conversation.
Requesting for a special use?
This isn't that's not relevant to this conversation. This is approving zoning that regulates the use of land. And if we don't have an ordinance on the books in the code in the zoning, then we can't regulate it.
Mr. Featherling,
Kate, I've been doing this kind of stuff for quite a while, many years actually, and I've had the experience over the years is that it's better to have action in place than have to react when it's too late. That's the way I feel about the ordinance. That the zoning part of this needs to be in place. So if somebody comes in, they need a special use permit, they need to go in front of the zoning board of appeals, it needs to come to the PZA, and then it needs to go to the county board. There's, I guess, somewhere around 30 people. They're gonna have different people. They're gonna have a say in this particular thing. When somebody wants to put one in on 10,000 Road or whatever, and it's gonna come in and everybody's gonna get a chance to look at it. If they don't feel as though it's the right place, they don't feel as though it's the right position, it's not the right neighborhood, right people, they didn't go about the procedure right or whatever, you have the access, the ability to deny it without opening yourself up for all kinds of trouble.
Yeah, what this ordinance does, if you want to establish one of these, and if the county board approves it, these are the regulations you must meet. The big word there is if on both parts. Nothing in this ordinance requires the county board to approve any of these.
any others? Ready for a vote? Oh, Mr. Fairfield?
It's against my heart to vote for this, but I guess I'm gonna have to. I'm not for marijuana use anyway, fact or whatever, but I think the right thing to do is to vote for the ordinance.
Okay, I understand. Del, if we didn't have this, if this was voted down, then what would happen? I mean, what would be the next thing to do, or?
We would have no way to regulate one of these facilities if someone asked for one.
Would they be able to get it?
Quite possibly, yes. You don't have anything to say for them not to.
Pardon? Oh. Well, but Mr. Featherling?
I was gonna say that, you know, Dell's gone through a considerable amount of time. This has gone in front of the zoning board of appeals?
Yes, and they unanimously voted to recommend approval.
Okay, so it didn't have any referrals to any
There
findings in
was-
that particular place?
The findings are, they agreed with our findings.
Okay, the responses to your findings?
Responses to our
Okay.
findings, which is only the first two.
Okay.
Text amendments, the other ones don't apply to. Yeah, there was no objectors. There was no public comment at the hearing.
Mm-hmm. Nobody was there?
No.
Basically. Mr. Altoff, were you there?
I was not there.
Okay, thank you.
All right, you ready for the vote? Roll call's been asked.
Mr. Olthoff? Mr. Featherling?
Yeah.
Mr. Washington?
Aye.
Ms. Polk?
Aye.
Ms. Dunbar?
Aye.
Mr. Kinzinger?
Nay.
Mr. Fairfield?
Aye.
Mr. Smith?
No.
Mr. Swanson?
Aye.
Mr. Dennell?
Aye.
Mr. Seroy?
Aye.
Motion carries.
Okay, on to taxes. Allowance for cannabis dispensing facility in unincorporated areas of Kankakee County.
I believe at the last county board meeting, the county board voted to approve the tax. Is that correct, Todd?
Yes.
Yeah, so the tax part's in place. Go ahead.
And with that discussion we just had, this, you know, and I want to remind this committee again that we don't control the whole county. We don't control, the municipalities will be able to do what they want to do with that. Now we control the unincorporated areas, and if a sale of marijuana happens in a municipality, we're going to get 0.75% of that tax revenue, whatever that tax percentage is. If it happens in the unincorporated area, we're going to get 3.75. Now, with what Mr. Beavis spoke about it, and, you know, I'm sure his numbers from the economic and social costs of legalization of marijuana from the Centennial Institute of Colorado Christian University, published on November 15th, 2018, are correct. For every dollar we receive in taxes, it's going to cost us $4.50 on the back end. Now, this isn't our decision, fellas, ladies and gentlemen. We didn't make this. But if we're going to have to spend $4.50 on the back end, what's that going to make our revenue side going forward in years to come? That's my point. And I don't like it as much as you guys do. You know, how many in here have a CDL? We can't ever partake in it. So I'm not going to reap any of the benefits of whatever the state has done to allow it. You know, I can drink my beer. That's all I get to do.
Not while you're driving your school bus.
Not while I'm driving my school bus, but believe me, at the end of the day, I might have a couple. So I just want to make sure that when we go through these, and these special use permits are going to allow that, you know, and if you don't want it in your district, I would truly support whatever your district would like. But we're not going to be able to prevent the municipalities from having these things. And I would hate to lose tax revenue that we're going to have to spend $4.50 over the long run for every dollar, lose that revenue in years to come to not be able to fund the things that we're going to need to fund.
Can I ask you a question?
Sure.
Is the 450 take place if you don't have it in your unincorporated area?
Yeah, because it's general. I mean, I think we're gonna have to spend it regardless. Because it's not like that we can prevent somebody in our area from going and purchasing it someplace else. I mean, we're not, this vote isn't for or against marijuana sales. That's already been done. This is gonna be, we're gonna have to spend some dollars down the road.
The municipality can charge 3.75, and we get 0.75 of that.
Of that, right? So that's where I'm at, the numbers part of it, because the moral issue has already been voted on. I'm sorry, but I'm at the numbers part of it, and if we're gonna have to spend it, what are we gonna have to cut later if we're always looking for an income source?
Well, it sounds like that's in place now, right? The 3.75?
Yeah.
As of the last county board meeting.
Yeah.
Okay.
Yes.
Are you finished, Mr. Sears?
Yes, sir. Thank you.
7. Okay.
Thanks, Mr. Chairman. I think Chairman Wheeler said last time the municipalities are capped at 3%, and we could have 7.75 of that. Is that right?
Yeah. I didn't bring that paper.
Why do we get allowed 3.75 if they're capped at 3?
0.75.
Right, the tax is 3.75. If it's in a municipality, they get 3%, we get 0.75. If it's in the county, we get the entire 3.75.
Yeah, what I heard him saying was the municipality was capped at 3%. Okay. They're gonna be paying 3.75, they're capped at 3, got it. All right, Mr. Kinzinger.
Regarding an earlier conversation from Mr. Sirois, he's correct that if an accident occurs in Kankakee County and it's due to a cannabis, we may be sued because something isn't right and we are going to be responsible. However, not doing something is a good defense in a court of law. We didn't allow that to happen in this county. They did it somewhere else and brought it to our county. So from that standpoint, although we have legal reference, we may not collect any money, but I think it's important that we set forth an example of how we are supposed to conduct ourselves in the public.
We're not voting on anything here, correct?
No, this was just a discussion.
Some discussion. I just wanna get the committee's feelings on dispensaries in the unincorporated area. Just because we're not gonna be able to control the municipalities. We're not gonna be able to control the municipalities on what they do. So if whoever wants to sell it, they can sell it in their municipality, and everybody can drive there and smoke it in the facility like the ordinance says,
And in the county.
and drive back.
Yep. They'll be able to take it anywhere in the state of Illinois, so they can certainly go to Joliet and buy it and bring it back here.
Yeah.
So,
Mr. Washington.
I'd like to remind everybody, and that sounds like I'm beating a dead horse, but I can remember when this board voted to put a tax cap on our taxes that we could raise, and look at what we've suffered through for the last 13 years. If we're going to do something and we're going to accept the fact that we have taxes, then we're going to have to pay taxes, and we're going to have to use those taxes in order to sustain county government. We had better look very closely before we decide to turn something down.
Are there any other vices we should tax?
I don't know. You can tell us more about that, Bill.
Shall we list them? All right, I guess we can move on. Wind farm update.
yes, there's been some new trends happening in the wind farm industry that may prompt, well, will if this committee approves of it, prompt some changes to our wind farm ordinance. I've asked Mr. James Madsen from Pattern Development to come up here and talk a little bit on what those trends are. And so, James.
Looks like you talk a lot of it.
Let's see.
Everybody hear me okay?
Yeah, tip it up. Tip up the mic a little bit.
Just go like that.
There you go.
A little
That's
better.
good. Yeah.
My former life as a rock star, I don't know how to work these things.
Really? Would you like to give us a
My
selection?
hair was long. And, well, first of all, a thank you to Delbert, to the committee for making some time and putting some time on the agenda and having a listen. So everyone should have a presentation in front of them, as well as a business card in there that's got my phone number, company name, that sort of stuff. If you want to reach out about any questions you have at all, either about our project, which I'll just touch on very lightly. Because it's less of a wind farm update, maybe more of a wind energy update or a wind technology update is really kind of the goal for today. But to introduce myself, James Madsen with Pattern Development. I've been doing wind development, some solar development for about 17, 18 years now. Worked for a few different companies, but have done quite a bit of work in Illinois and just over the border in Indiana. Benton County, for example, has got quite a few turbines. In a past life, I worked for BP, which built a big chunk of those turbines over there as well. So wanted to, we are working on a project, wind energy project in Kankakee over in the western portion of the county, kind of Norton Pilot, Essex, Salina areas, kind of where some of those come together. But and happy to talk about that more, whether it's in this meeting or outside the meeting. But wanted to make it more about, again, technology update and how that relates to the current ordinance and wind development or potential wind development in Kankakee County beyond the Kelly Creek Wind Farm and the Pilot Hill Wind Farm that you've got some portions of down in the southwest. So on the first slide there, you can kind of see, the graph kind of tells the picture. This is just generally wind energy in the United States, cumulatively in the US. 1999 on the left side of the graph and 2018 on the right side of the graph. So you can see the columns are the additions every year, and then the line that you can kind of see that slopes upwards and to the right are the cumulative megawatts in terms of capacity in the United States. You can kind of see year on year how the industry continues to grow and kind of see success across the country. One other thing to point out in the fine print down there is there's about 60,000 turbines, individual wind turbines right now operating in the United States and continuing to grow. So very much a wealth of experience. We were talking earlier about California being some of the early adopters, but now states like Texas, Iowa, and Illinois actually are among the top states for adoption of wind energy. So flipping to the next slide, 3, kind of a similar way of saying the same thing. Blue dots are wind turbines that were built prior, wind farms that were built prior to 2018. And then the orange dots are ones built in 2018. And then this data obviously ends at the end of 2018. But you can still see companies building in the state of Illinois and other regions. Really, really windy in the central portion, north-south, central portion of the U.S. And I don't want to get on a tangent about electrical transmission, but the interesting part is the windiest parts are in the center of the country, and a lot of the population centers can tend to be, some of those big cities on the coasts and other things like that. So that's always one of the issues with renewable energy is how do you get that power to market. But flipping to page 4. And not my meeting to run, but feel free to interrupt or ask questions and that sort of stuff, of course, if folks have questions. So you can kind of see on this map that Illinois has been a leader. Texas is just a huge, speak about zoning or lack thereof, and a massive land mass. But you can see Illinois is amongst the leaders in new wind energy deployment in the U.S. On to slide 5. So this kind of gets into a much more local part of the presentation. And wind technology has been steadily advancing to taller, and I'll talk about that on the next slide, what that really means, taller and more powerful turbines to allow for improved project performance, lower cost of energy, which is good when we're selling our power for less. Then that, in eventuality, it doesn't happen overnight, but in eventuality leads to lower power prices across the board, which is, I think, good for all users of energy, which we certainly all are. And also allows for fewer turbines to be actually put into the field to produce the same amount of power, and I'll talk about that a little bit more. So wind energy developers, not just our company, but any developers, there's one other project that I know of, and maybe there's other developments that I don't know of, really would like and need the ability to use these more efficient technologies that have the advantages of the new research and development, lighter materials, more powerful turbines, more improved controls and safety equipment on the turbines. All of the the best of what these major turbine manufacturers are putting into these new technologies. Yes, sir.
Will the trend be to replace the turbines that are present with the new turbines over time?
Eventually, yeah, and I think it's a really good question because actually Illinois, and I mentioned prior to the meeting, there's something called repowering, and when a turbine gets to, it doesn't even have to be at the end of its life necessarily, but you might have, say, 100 1-megawatt turbines, and you could, in theory, replace that with 50 2-megawatt turbines, and you get the same amount of power out of that wind farm, but you only have 50 instead of 100 on the landscape, and creating sound and lights and these sorts of things. So I think that's a very nice trend. Now, I would say that the general useful life of a turbine, a foundation, a farm in general is anywhere from 20 to 25 years. That's kind of somewhat the natural life. They can definitely last longer than that with good maintenance practices, kind of like a car, piece of rotating equipment, that sort of thing. But Illinois is actually one of the first states to have one of the original wind farms from, I think it was about 15 years ago up north. I think it may be in the Rockford area, that is actually going through, or maybe just finishing, a repowering now, and it's taking some of those older technologies and putting up new ones. Really putting them in the same spots, using a lot of the same infrastructure, the same underground cabling, so you're not, kind of stressing out the fields and going through a full construction process. But it's a great question. So kind of getting into it, I think here's where kind of the rubber meets the road in terms of the ordinance on slide 6. And here's just a snippet here of some of what I call the physical setbacks. And you can see in my sentence there on the bottom of the slide, the current ordinance in the county does have a significant number of additional requirements. So this isn't a comprehensive table, such as a site plan, noise analysis, decommissioning plan, as well as financial assurance, environmental plans, emergency services plans, safety plans. These are all, signage, 911 interaction. So these are all other parts of the ordinance that aren't, kind of touched on here today. But the physical setbacks, when I talk about taller towers, the current ordinance for wind energy systems is at 499 feet for the Kankakee County, a cap. And what that means, let me see, I'm going to flip to the next slide and I'll come back. But just to give you a sense, here's the actual turbine itself. And so what we talk about there is the tower. And then when you put a blade straight up in the air, that's the maximum height of that turbine. We call it the tip height, basically when that blade is pointed straight up in the air. So I'll go back to slide 6 here. So right now that maximum height's limited at 499 feet. And similar to, for example, Woodford County right now actually has an ordinance that has no limit. I'm not suggesting that, but has no limit on turbine technology. They really put a requirement in that you have to prove that it's designed to the same standards, has the same engineering principles, the same stamps, the same everything that goes into the design and creation of a turbine that gets put into construction and into operation. So the suggestion here to do what I kind of call future-proofing the ordinance, which is, when you put an ordinance in place, you want that, you don't want to be coming back every year and saying, okay, well, we're going to go from 499 feet to 510 and then 520 and 540. That's not really good use, in my opinion, of people's time. So you want that to, survive for 5 to 10 years and kind of be applicable. So the suggested amendment would be 699 feet. And that's to include technology that's currently on the market today. My company in Canada is actually installing 87 656-foot tall turbines, and that's on the higher end right now, but it is part of a trend of going to larger, more productive turbines. So you can kind of see the current in the middle column, and then the suggestion in the column on the right-hand side. So as part of that going bigger, you have what I call static setbacks and dynamic setbacks. So one way to measure a setback is to say you're going to be 1.1 times the tip height, for example, or the tower height or something like that. And if you do the math on that, that changes. So the taller the turbine, the bigger the setback, which is a very, I think a very common way, I know a very common way to handle the larger turbine technology, so that you're putting them further away from schools, homes, structures, these sorts of things. So as we get into the second line item and the third line item, you'll see some green text over there on the right. So going from 499 to 699 feet, but also taking right now the primary structure setback, which consider it basically a home, is 1,200 feet. So it's a static number, whether that's a 200-foot tall turbine or a 699-foot turbine. So the suggestion would be to go to the greater of that 1,200 feet. So you still have that minimum if you have a smaller turbine, because going bigger doesn't mean someone will put that in place or suggest to put that in place. It just means you have the option to do that. So greater of 1,200 feet or 2 times the tower height. And that way, say you have a 699-foot turbine, to be dramatic on the top end, then you basically have a 1,400-foot setback from home. So you are increasing that setback as you get to a larger size turbine. And then on the third row there, primary structure setback from a participating property, right now it's a static setback of 600 feet regardless of the size. That's in the current ordinance. My suggestion would be you actually go up to, the industry standard has gone actually a little bit higher, to a minimum of 1,000 feet and 1.5 times the tower height. So a bit closer there if someone is signed up for the project and a participant in the project. Yes, sir.
Regulations or considerations are that being given for we have crop dusters
Hmm.
and airplanes that fly in those areas where
Yep.
you're talking about 1,000 feet. You know, what is there any coordination between the companies and National Aeronautics or someone who
Yes.
regulates that?
Yeah, absolutely. So there's kind of multiple levels of that. So at the federal level, there's the Federal Aviation Administration, and any structure actually over 200 feet, whether it's a barn, a cell tower, or a wind turbine, any structure over 200 feet has to go through the FAA's approval process. And the FAA runs the process, but there's about 8 or 9 different entities that are a part of that process. Department of Homeland Security, NORAD, there's different, there's military stuff, there's weather stuff, all those different entities that are part of that. And especially when you get to these bigger turbines, they also circulate these applications amongst other more local organizations, state level, or even different associations, crop dusters, or sometimes they're called aerial applicators associations, will also get those notices and have a chance to give their input to that process. And then there's also marking and lighting requirements for the colors you have to paint the turbine for visibility during the day, and then the lighting requirements for visibility at night. And one of the reasons that I actually have 699 feet here is that above 699, when you get to 700, there's significantly more lighting that needs to be put on a turbine that then just kind of adds even more light pollution that from a technology perspective, isn't helpful for the wind industry because we're not building 700 plus turbines, but is sort of just harmful from a light pollution perspective, in my opinion. So I think that 699 is a balance of those two things. But it is, I mean, the reality is it's a concern for, if you've got these big structures out there for folks that are flying. Now, different, I think folks that fly, doing crop dusting have different opinions on these sorts of things. But generally speaking, if you know what's out there, you can work within it. But some have different opinions on that. And so it's a topic for discussion, for sure.
George, I guess you could say flyer beware.
I wouldn't put it that way. We do like to interact with those local societies to make sure, but yeah. And there are also situations where, and I know this is an option where wind companies can also, if because these crop dusters aren't out in every field every day, it's a rarity, and so you can have situations where you work with the operator to actually shut down the turbine, put the brakes on, turn the turbine in a certain direction so that someone can come in and spray. And you do that for 2 hours. You might lose a little bit of revenue for the wind company, kind of a thing, but it really, in terms of a public safety aspect, I think it's a smart thing.
What I was thinking also about was we have several small airports around, and people fly recreationally, and they'd have to be given consideration too for where those turbines are placed.
That's right, and there are, so there definitely are, and there's, depending on the length of the strip, there's different regulations in place. But for folks that, again, we go through the federal process, and then that federal process has notifications to anyone within I don't know the exact distance, but anyone within a vicinity that kind of uses that airspace, that's known to use that airspace. So sometimes it's hard to tell exactly who, especially if it's a small, I don't know, a Piper Cub, and maybe somebody's new to the area. Sometimes there can be gaps there, but at the end of the day, I think as a pilot, I'm not a pilot, but the ones that I've spoken to are generally pretty darn good about when they're going to fly a certain area. They're checking the maps, checking for obstacles, seeing what's out there, and trying to really be ahead of the game in terms of what they might run into and what they might see when they're out there. So,
thank you.
Yeah, good question. And then, so there's a few other setbacks in here that are already what I would call dynamic, and so already scale with the size of the turbine. Things like 1.1 times tower height on slide 6 there. So those ones already increase with size with the bigger turbines. So I think you guys already have a good ordinance that can adapt to these larger technologies. So sorry, I'll speed up a little bit. I don't want to take too much of people's time, but you can kind of see here on slide 7 how the sizes have increased, and apologies, In this slide, it's in meters. In a follow-on slide, it's actually in feet. But what you really kind of see there in the year 2000, the overall height of the turbine was about 269 feet, average height. In 2018, it was 479 feet. In 2019, it will be above 500 feet. And so technology today that's being deployed is already exceeding, on average, is already exceeding what the ordinance currently allows. So that's kind of why we're here. Flipping through to the next page, a lot of really fine print, and don't suggest straining the eyes, but of course you can. The point here is these are some excerpts from three of the top three manufacturers on the planet. General Electric, Siemens, and Vestas are the three companies. These are some excerpts from their technical specifications to show that the design standards for these larger turbines are the same for the average size and kind of smaller size turbines. So it's really kind of a bit of a scaling up. So you have a stiffer tower, slightly bigger foundation, but really all the same design criteria are the same for using international design codes, Electrotechnical Commission, ISO standards organizations, which are international as well and very common in the US. So that's really kind of the point of this slide. So moving along to slide 9, really the punchline here is in red that allowing these taller turbines might seem like, okay, well, these might be bigger on the landscape, but these are going to allow us to install fewer turbines because we build basically to a certain number of megawatts, say 200 megawatt farm. And so if you have a 200 megawatt cap, you can do the math. If you have a 2 megawatt turbine versus a 4 megawatt turbine, you're gonna build half of the number of turbines if you build that 4 megawatt turbine. So fewer turbines on the landscape, fewer lights, these sorts of things.
How does this affect the tax situation?
Tax situation is the same, actually. Fewer turbines because the state of Illinois taxes on a per megawatt basis. So that 200 megawatt farm is still going to be a 200 megawatt farm.
As far as permitting goes, it'd be less.
As far as permitting goes, there will be fewer of them. So fewer, instead of the we were talking about special use permits, instead of the binder being 6 inches, it'll be 5 maybe or something like that. But it will, allow for fewer structures to be reviewed and approved and meeting setbacks and those sorts of things.
The permitting stay the same?
Depends on how the permit's calculated. If it's calculated by per megawatt, then no, it wouldn't. If it's by the number of towers, then the permit fee might be less. Generally, though, our permit fees are based on the cost of the project, and I'm guessing that doesn't change that much.
That's right. Yeah, so the special use permit fee, I think, is still $50,000, kind of a flat number. But then, yeah, the permit fees, from what I've seen from some of the Met Tower permit fees and things, yeah, it's more of a percentage of the capital and the cost, which would roughly be the same.
Okay.
Okay, and then one other point, because sound actually is talked about, and sometimes people think, okay, well, these big turbines are going to make so much more noise. But 2 points. One is that if they were to make more noise, that means you have to set them back even further, because the Illinois Pollution Control Board has standards that we follow that are actually quite stringent. And so even if you had something that's quote unquote noisier, you simply have to move it further back from a home or something like that in order to meet those same sound standards. So it wouldn't be that creates a noisier environment. But the way that the manufacturers have been working on this is that they know that, and they know that setbacks are going to be bigger, and that sound is an issue. And so they've actually designed these larger turbines to actually reduce the revolutions per minute on the rotation, because noise is largely a function of tip speed. That's the kind of that tip cutting through the air is the sound that you hear, kind of that whoosh of a turbine as you might drive by or something. They actually reduce the RPM, so the tip speed stays the same, and therefore the noise stays the same from a bigger turbine versus a medium-sized turbine, which I think is a good thing, and something that is very much a design criteria that had communities in mind and trying to be a good neighbor to communities in mind. Okay, so on to 10 is really, and I think we can move pretty quick, but this really goes back to that initial slide with the green lettering on it. So this is language in the current ordinance on the top, and then suggested language on the bottom that reflects the change from, in this case, I did them in order the way they're listed in the ordinance, but in this case, this is the change to 1,000 feet or 1.5 times the tower height. And then on slide 11, it is a change to 1,200 feet or 2 times the tower height to kind of grow with the turbine size as a minimum distance. And then on slide 12, you can see the very simple change from 499 feet to 699 feet as suggested as well. And then a little less relevant, but I always kind of try to put some of these talking points in here. So in terms of county level benefits, because you know, there's certainly the top bullet there, the thing that people think about the most is, okay, well, if we put the turbine on somebody's property, that landowner is going to get direct payments. They actually get a portion of the gross revenue of the farm, which can be a nice amount of money, especially when each turbine only takes out of service about 1/2 acre to 1 acre of ag land, generally speaking. So an average 200 megawatt wind farm will bring in about $1 million per year in the first 10 years, increasing to about almost $2 million in years 20 plus in terms of direct payments to landowners. And the reason I bring that up is not to single those landowners out, but just to simply say, not only is that good for those folks, but it also, we've seen that it has a trickle down effect, you could say, that people are then reinvesting that money in their farms. They're, maybe eating out a bit more with some of that money, whatever the case may be. There's some additional benefits that are indirect in terms of the county. But really, when it gets into it, are the bullets 2, 3, and 4. Property tax revenue. So we talked about that a little bit. 200 megawatt wind farm brings in roughly $2 million per year increase in the tax base. And then I think you all kind of know the tax cards probably fairly well, but about 60% of that goes to the school districts where the wind farm is actually built, where those turbines are located. And the next big chunks of that go to the county general budget, fire budget, township budget are kind of the breakdowns of some of those pieces. So those are benefits that are going back into the community, not to the landowners that are housing the turbines, not revenue to the wind farm, but directly to benefit schools, townships, that sort of stuff. Yes, sir.
With these more efficient, cost-effective turbines, does the developer, do these become economically viable for the developer without federal tax incentives?
Yes, okay. Actually, they start to become, yes. And so that's a really good question, because it's something that our industry is actually quite proud of, that back in the early 90s, I don't want to get too far off on a tangent, but it's easy for me to do. Back in the early 90s, Chuck Grassley, actually out of Iowa, was kind of called the father of the production tax credit, which is a tax credit for actual produced kilowatt hours. And that really helped. The point was to spur the industry on, because it was a high cost of energy, expensive equipment, and you could get it cheaper from a coal plant or a nuke plant or other things like that. And so over time, now with advancements in research and development, going with taller towers, better financing techniques to kind of cut out some of those costs, the cost of energy for wind and solar, for that matter, has now dropped to the lowest cost of new form of energy that you can possibly produce, especially in the state of Illinois, where wind is relatively strong, as you all know. So it used to be said that that's kind of with some of those tax credits, but one of the things the industry's done about 2 years ago, agreed to phasing out those tax credits over a 5-year period, and we're actually in the middle of that phase out now. So if we build this farm, for example, our farm, in the timeline that I think we will, we're actually going to only get 60% of the tax credit that has been in place for the past couple decades, and then it's 40% the year after that, and then 0 the year after that. So we're actually in the middle of a phase out to where there's no tax dollars, and it's still basically on par with natural gas, or sometimes even cheaper than natural gas to produce the energy. So I think it's a really good success story for those tax credits and the ability to wean off of those tax credits, which is the whole point. It's not to survive on the tax credits for forever. I agree. Okay, and then one of the things that you mind popping up the other presentation real quick? And I'll make this one pretty short, but I think this is, in terms of the process, and Delbert's obviously the expert, but the next step would be a meeting with the, if get the blessing, would be a meeting with the Zoning Board of Appeals, and then actually coming back to this committee to have a more formal kind of a vote on actual text amendments, that sort of stuff. And then the county board would be the standard process. As part of that, I can stand up here. I work for a for-profit company. This is my job. I love doing what I do, but that can naturally, if it wasn't in your head, now I'm gonna, regret that I planted it in your head. But I could come up here and be biased, of course, in my outlook. So one of the things that we try and do is Burns and McDonnell. Some folks may have heard of them. They're a nationwide, a pretty big engineering firm based out of Kansas City, but they have offices in Chicago and kind of all over. They do a lot of work in the wind space, have a lot of expertise in these sorts of things. So I actually had Burns and McDonnell put together, separate from what I've done, but put together a presentation on some of these same topics in deploying some of these larger turbines. And I will also have the engineer that put this together, professional engineer that put this together, come and be part of the ZBA process and the PZA process, and allow you all to even pepper him with questions, and he'll be even smarter than me in terms of some other topics, but especially things like we've talked about loads in the past, and how is this going to impact roads and things like that. So that'll be a good topic to kind of talk about. So and this, it feels like I put him up to using this slide, but this is basically the same slide that I used from an annual market report. He was smarter than me and flipped it over to feet straight off the bat, so you can kind of see how some of that growth has occurred in the industry over time. But getting into design, so these higher structural loads, larger turbines, are accounted for in the component design and the foundation design, meaning that the tower might be stiffer, the foundation might be a little more substantial. We're not talking about double the size of the foundation or triple or anything like that, but incrementally, 5-10% bigger, something like that. Something that you wouldn't even notice, if you looked at the Kelly Creek wind farm versus, say, a new wind farm next year or the year after. From a communications perspective, so same methodologies that are used to make sure that things like microwave communications, especially emergency services, are not interrupted. We have to go through the exact same process, even with a bigger turbine. And that's part of the county ordinance as well, to make sure that there's no interruptions to any of those types of especially emergency services, but also making sure that we all get to see Monday Night Football when that comes on. And I am a Packer fan. I probably shouldn't announce that, but I grew up in Wisconsin, so.
No, you're sitting there.
Yeah. Anyway. Anyway, so, but the point is there,
Is there a second?
It's again being a good neighbor and trying to give you all comfort that we are working with the community as part of the process to make sure that these turbines aren't causing issues. The gentleman asked about aviation impacts as well, so that's talked about a little bit here, cited to minimize interference regardless of size. And things like noise we talked about a little bit, or shadow flicker. So there's ways that you look at these sorts of and you analyze these sorts of potential impacts, and you adjust them for that size of turbine. So it's really all the same. It's the same approach, the same design criteria, the same way you deploy these turbines. They're just simply a bit larger. So and you account for that and make adjustments for that in certain ways. And then transportation was one that I know folks can think about, roads and component weights and things. So you think about these bigger turbines, they are heavier, but really the only what ends up happening is that the limitations on county roads are set by, the county, or limitations in bridge limits and other things like that. So at the end of the day, you can't exceed those. So what they do is actually break the turbine down into more loads of the same weights, kind of. So they're significant weights. For example, a current blade can be anywhere from, say, 12 to 15 tons, with, I've been told, getting up to even close to maybe even 20 tons for some of the larger blades. But as part of the current ordinance that the county already has in place, you have to have a road use agreement and basically a logistics plan that puts the onus on the company, that we have to actually document and we video the actual roads and the routes that these trucks will take. video them ahead of time, document the condition, improve the condition prior to us coming in to do construction, do maintenance while construction is going on, and have things like dust mitigation, other things like that. And then after construction's completed, to then revamp those roads back up to the, you know, the high quality that is needed. So I think what you find by and large, and it's not perfect, but by and large, I know even with Kelly Creek, there were some ongoing issues that I think are just now starting to get fully finished up, especially in Ford County, but I know probably in this county as well. That in the end, you do end up with rather nice roads in the vicinity of that wind farm, usually nice and wide, flat, you know, high quality. And then the wind farm is actually required to maintain those roads throughout the life. So if we bring in another big crane because we have to change out a big gearbox or something, we are then responsible for that on a case-by-case basis as well. So there's some protections there. But yeah, as you can probably see on the slide here, a few more deliveries, but the same weights that are actually occurring with the larger turbines. And then this is the gentleman's name from the engineering firm with a direct phone number and email address as well, if you ever want to give him a call and ask him about it. I think he's a good guy, been in the industry quite a while and seen quite a bit. So anyways, that's I'm out of breath, so that's the end of my presentation. Happy to answer any more questions. Otherwise, really, you know, would hope to be able to, of course, address this again in a ZBA meeting and yet again another PZA meeting and county board meeting. Thank you very much.
Thank you. No other questions? Okay. Any old
So-
business?
Well, hang on.
Oh.
So what we're asking for today is is permission to forward this to zoning board for public hearing.
So moved.
Moved by Mr. Washington, second by Mr. Polk. All in favor, say aye.
Aye.
Opposed? Motion carried. Now, any old business? Any new business?
I believe Jeffrey and Ben have something very short,
Oh,
just to mention to you.
I want to thank Jeffrey and Ben for speaking. Is there a motion?
Good morning. 30 seconds. The Transportation Department Division, we're updating our long-range plan. We have a survey open right now. The website is on our program website, www.cats-mpo.org/survey, and I've got handouts for you that you can take with you. If you can take it, it'd be much appreciated.
Oh, that was quick.
Here we go.
I don't know that I can do it that fast, but let's try. I actually only have one announcement. We're hosting a seminar with the local jurisdictions and the county. Illinois Department of Commerce and USDA Rural Development are going to come in on October 9th, library 4th floor, 10:30 in the morning till about noon. We're going to have the program people on the ground talk about some business development and community development grants that are available. I think that there's some funds that are available. We keep, getting information from the local representative's office, from state contacts. I think it'd be good to have just kind of a single function, bring the communities in, allow them to ask questions, and then it affords at least the Department of Commerce, who's trying to get out more into communities. This gives them, a crack at 20 communities at one meeting. So we're able to kind of, facilitate that for them, and they're pretty happy about doing those types of meetings. So October 9th, 10:30 in the morning, 4th floor in the library. Thank you.
Thank you.
How long you figure something like that takes to schedule in?
90 minutes. I got the room from 10 to 2, but I figure we're probably right around 90 minutes. Everybody will get hungry, and then we'll kind of disperse. No, we're not. So we're not feeding you. So you gotta leave and go find it. So, thank you.
Okay, thank you.
It's October 9th.
At the end of new business? Would you attend that meeting? I think so. This meeting? Yes.
I'd like to,
Yeah, I'd like to thank Mr. Altoff for all of his years of being chairman of this committee. I was on the zoning board of appeals for 15 years and saw him out in the crowd. We knew we were in trouble if he was there. It was something going to be big, and I wanted to thank him for his time.
Well, thank you for that, and that will not be put to a vote.
No.
It's been my pleasure to serve
Yeah.
and on this committee for these number of years, 17, I think.
Yeah.
And it's been a joy. Appreciate working with Dell and the staff. They've all been great. And looking forward to the next section of life. So thank you very much. Motion to adjourn to be in order. Mr. Siroy, second by Mr. Featherling. Oh, I'm sorry. Ms. Polk says she had her hand up before you did. Ms. Polk. All in favor, say aye.
Aye.
Opposed? Motion carried. Thank you.